So good morning, everybody. We're just welcome everybody to the session. So we'll just take a minute to let everybody arrive. Now. So I think we'll start. I know there's more people going to arrive, but just so we can do the introduction. So you'll see on the bottom of the screen here, everything that we discuss here today is going to be translated into Ukrainian. We're also recording the session, and this will be available to people afterwards. So don't worry, there's going to be a lot of information today, but you will get the recording and you can go back over what we spoke about. So just to introduce ourselves, so my name is Lisa Fingleton, and I coordinate a project called Moving On with my colleague, Lisa O'Flaherty. And our project specifically supports women into employment in the Kerry region, but we also work with employers and people outside this area. So Moving On is managed by NEWKD here in Kerry, and we are co-funded by the Irish government and the European Social Fund under a programme called PEIL, P-E-I-L. So today we're absolutely delighted to welcome Jane O'Sullivan and Ros Palmer from Community Law and Mediation. And we were just talking before the seminar about how long this organisation is in Ireland. So we came up with 46 years, and that it was founded around the same time as the civil rights, I suppose, law agencies were founded in America. So it seems very fitting that we're here today to discuss something as important as employment law in Ireland. So that's really it. I suppose Jane will explain how she's going to run the webinar, and the opportunities. If you have questions, I'm imagining that we put them into the Q&A, but I'll leave that up to you, Jane, to decide. And as I said, this recording will be available afterwards. You are all very welcome, and it's great that you're here. Thank you.
Thank you very much, Lisa. So I'm delighted to be talking to you here today. While I'm very conscious of the circumstances that brought you here, I really hope that today's session will be of use to you and to people you know going forward. So my name is Jane, and I am a solicitor working in Community Law and Mediation, which is a charity that provides free legal advice and representation and mediation services and education services like the one today. So as we go along, I'll try and keep it as light as possible, but there is a lot of information in here. But there will be an opportunity to ask questions in the Q&A if you so wish. And I will give you details as I go on of the legal advice clinics that you can access if you have issues with your employment. So just to get started then, so we'll be talking today about employment rights in Ireland for Ukrainian citizens. So the first big question, of course, and this is probably one that you're all well aware of, but just to underline, so can you work in Ireland? So Ukrainian citizens can work legally in Ireland once you've received your letter confirming that you have been granted temporary protection under the EU directive. So at that point, then you are entitled to the same rights, the same statutory employment rights and protections as Irish workers. And when I say statutory employment rights, what I mean is those are the employment rights that come from our statutes or from our laws. And some of the employment rights that we'll go through came from our statutes and our laws, but also from the interpretation of those laws by our judges in the courts. So the first thing is your employment contract. So this will govern your relationship with your employer. So under the Terms of Information Act, you must receive a written statement of the core terms of your employment within only 5 days of starting work. So this is quite a new obligation on employers. So in those first 5 days, you have to receive the following very basic information in writing. So your name as the employee and the name of the employer, the address of the employer, the contract duration, so how long the contract is going to last, and the calculation of pay and the number of hours the employee is expected to work per day or per week. So you must then receive a full written statement of the terms and conditions of your employment. So your full employment contract, so including things like sick leave, annual leave, all of those items that are required in a contract. You have to receive that within 2 months of starting your work. So your employer cannot make substantial changes to your contract without your written consent. So if your employer tries to change the terms and conditions of your employment, you have the right to not agree to those changes. Once you have a written contract, you're entitled to rely on that contract. So what if your employer refuses to give you a contract? And I come across this all the time, that people have been working maybe in their jobs for years and don't have a written contract. So if you don't receive a contract, you can make a complaint to the Workplace Relations Commission under the Terms of Information Act. And the Workplace Relations Commission is where all employment law cases are taken in Ireland. So it's a slightly different system to the normal court system, in that it is less adversarial and it is supposed to be a more informal setting. So the important thing to remember that even if you don't have a written contract, you still have employment rights. So the next piece of legislation we move on to is the Payment of Wages Act. So all employees are entitled to a confidential written statement or a pay slip setting out your gross pay, so your pay before tax, and your net pay. Details of any deductions that are being made from your pay, your PRSI, which is your pay-related social insurance, your union dues if you decide to join a union. And it's very important to remember that your employer can only make deductions from wages when certain conditions are complied with. And those are if it's provided for by law, if it's allowed in the employee's contract, or if it's made with the written consent of the employee. So one example of that, an unlawful deduction being made, was a woman who came to the clinic to get some advice, and her employer had started to make deductions from her wages to pay for her work uniform. And that had not been included in the employee's contract. And so that was an unlawful deduction, which the employee did not agree to. So under the Payment of Wages Act, all employees in Ireland are entitled to a minimum hourly wage rate. So that applies, the same rate applies whether you're a full-time, part-time, temporary or casual employee, or a seasonal worker. So a seasonal worker would be somebody who works during particular seasons. So for example, works on a farm, for example, for the harvest, those types of jobs. So employees under 20 years of age have reduced rates, which you can see in the box below. So again, all employees must receive a payslip. That's it, very important to receive a payslip. And the rates this year are $7.35 for under 18, $8.40 for over 18, 9.45 for 19 years old, people who are 19. And then for anybody who's 20 plus, it's €10.50 per hour is your minimum wage. And sometimes you'll get situations where employers try to pay people less to say, you know, you're only training, and this is a training period, so we're going to pay you less than the minimum wage. That is illegal. You have to be paid the minimum wage for all the hours that you work. So the Organisation of Working Time Act then, that covers elements like your annual leave. So all employees must receive a minimum of 4 of their working weeks in annual leave per year, so as holidays. So basically 4 weeks holidays per year is the minimum. Now there are there are contracts that you can enter into with your employer which might give you more annual leave than that, but that is the statutory minimum. So your annual leave is built up or accrued based on the time that you work as an employee. So leave for part-time employees is calculated on the basis of 8% of the hours worked. So for example, if you work 20 hours per week, you will be entitled to 8% of that time towards your annual leave entitlement. So the Act also deals with the maximum working time. So every employee can only work up to a maximum amount of hours per average week. And that maximum is 48 hours, and it is calculated over a 4-month period. Employees are entitled to a daily rest break of 11 hours per 24 hours and a weekly rest period of 24 consecutive hours per 7 days. So you're not supposed to be working 7 days in a row. You're supposed to get, if you're working for 6 days, you're then meant to get 24 hours of rest. So in terms of breaks then, so you should receive a 15-minute break after working 4.5 hours and a 30-minute break after working 6 hours. So that's important as well to note that when you have a break, it should be a proper break. So you should be able to, step away from, if it's a counter you're working at or a desk, you should be able to go off, make yourself a cup of coffee, whatever. And it is important that those breaks are given. And there is an obligation on your employer to make sure that the employees take their breaks as well. So there has to be that encouragement from the employer. So public holidays then, so most employees are entitled to paid leave on public holidays. So there is an exception for certain part-time employees that you can look into if that affects you. If you qualify for public holidays, you are entitled to one of the following. So you're either entitled to a paid day off on the public holiday itself. So for example, on St. Patrick's Day, which is a public holiday, or on Christmas Day, you're either entitled to a paid day off on that day, or if you're working that day, an additional day of annual leave, or an additional day's pay, or a paid day off within the month of the public holiday. So in terms of if your employment is terminated, so if you lose your job for reasons that we will go through later on, you're entitled to a minimum notice period. And the minimum notice periods are outlined in that box there. So up to 13 weeks, you're not entitled to notice. So 13 weeks to 2 years, you're entitled to 1 week, 2 to 5 years to 2 weeks, 5 to 10 years to 4 weeks, 10 to 15 years to 6 weeks, and over 15 years to 8 weeks notice. So that would apply in situations like redundancy, which we will talk about later on, or if you're dismissed for another reason from your employment. So in terms of part-time, agency and fixed-term workers, so a part-time worker is obvious, does not work full-time. An agency worker is somebody who works who works for an agency and gets posted to an employer or a company through that agency. And then a fixed term worker is where the worker is contracted to work for a fixed period of time. So, for example, you might get a contract for 6 months, or you might get a contract for a year. So Irish employment law doesn't, in general, distinguish between different categories of employees. Part-time employees are entitled to be treated no less favourably than full-time employees. So, for example, part-time employees are entitled to the same benefits that full-time employees have on a pro rata basis. So they're entitled to the same opportunities, they're entitled to the same leave, but on a pro rata basis. And similarly, and also to the same pay as on a pro rata basis as a full-time employee doing the same job as them. Similarly, fixed-term employees are entitled to be treated no less favourably than permanent employees. For those of you who are on fixed-term contracts, there are special protections and rules around fixed-term contracts that protect employees from being put onto continuous fixed-term contracts and never given a permanent contract. So if you need more information on that, you can either come to one of our clinics, you can book a consultation on the phone, or you can research it yourself on some of the links that I'll give you later on. So the Protection of Employees, the Temporary Agency Work Act in 2012 was enacted to give agency workers much the same rights and entitlements as permanent employees. So that was a very important one, because previously agency workers were in a very precarious situation with their employment. So moving on then to the Unfair Dismissals Acts, and I realise there's an awful lot of information in here today, and I'm trying to keep it as brief as possible, but I really want you to have the basics so that if you do find yourself in a situation where you need to know more about a particular area, you will know where to look and you will know what laws exist. So moving on to unfair dismissals, this is where you are dismissed from your job. So the Unfair Dismissals Acts, they provide fair grounds for dismissal. So the law doesn't say that an employer can never dismiss an employee, but they can only do so if there are fair grounds for the dismissal, and those grounds are contained in this Act. So to be protected by the Act, you have to have 1 year's at least continuous service, unless the dismissal is because of pregnancy or trade union membership or a few other elements that you will find if you look into it further. So dismissal is presumed to be unfair unless the employer can show that there were substantial grounds and that the employer acted fairly and reasonably and that the procedures were fair. So we'll see in some of the case law where so there was one example of a case where somebody was working in a petrol station, and at the end, where they sold newspapers as well, and at the end of the day they would wrap up all the newspapers to be collected again by the newspaper company, and they'd be wrapped up and they would be taken away, presumably to be shredded or whatever. So this employee had taken from that bundle of rubbish, essentially, had taken a magazine to bring home and read with them. And that employee was dismissed for doing that. And the WRC found that the employer had not acted fairly and reasonably in that situation, and that the sanction against the employee was completely disproportionate to the action of the employee. So there has to be reasonableness, and the dismissal has to be fair and rational and proportional. So, so Section 6 then of this Act says that an employee can be fairly dismissed if they are incapable of doing the job, if they don't have the qualifications to do the job. Because of conduct. So for example, if they assault another staff member, or they engage in conduct that is that warrants dismissal, whether if their job becomes redundant, or if their work becomes illegal. And what that means is, for example, if the employee has a working visa and is working away in a shop or a restaurant, but then that employee's visa expires and is no longer valid, and so it is actually illegal for the person to continue working. So to bring a claim for unfair dismissal, if you feel you've been unfairly dismissed, and that your employer has not acted fairly and reasonably, and has not put you through a proper disciplinary procedure, which is essential, you can bring a claim for unfair dismissal to the Workplace Relations Commission. So to do that, you have to fulfill certain conditions. So you have to be an employee and not a contractor. You have to have 1 year's continuous service. And again, there are exceptions to that are outlined there. And certain dismissals are deemed to be automatically unfair if they resulted from trade union membership, religious or political opinions, race, colour or sexual orientation, or other grounds as set out in the Acts. And we're going to take a look at the Employment Equality Acts later, because particularly as a group of women, you do get extra protections under the Employment Equality Acts against discrimination in the workplace. And in addition to that, there is a protection for under racial or ethnic grounds, for the prevention of racial discrimination as well. So we will go through those acts later on. So constructive dismissal then is where the employee has no other option but to resign due to the conduct of the employer. So that is where your conditions of work are just so unbearable, and your employer is so unreasonable that you really have no option but to leave your employment yourself and to resign. So the employee must prove at the WRC in these cases that their decision to leave the job was reasonable and that their employer acted unreasonably. So these cases can be very difficult to win because the burden of proof is on the employee to prove that they were reasonable. So the really important thing to remember here is that you should always follow the internal grievance procedures within the company first before you leave the job, and those procedures must be fair. And some people say, well, what's the point in raising an internal grievance? I know that my employer is not going to find in my favor. But the point is that, excuse me, to build a successful case of constructive dismissal, you must show that you tried to resolve the matter using all of the internal guidelines of the company. Excuse me. So your remedies then in cases of unfair dismissal. So if you go off to the Workplace Relations Commission and you're successful in your case, you're entitled to either reinstatement or re-engagement, so essentially to get your job back. But that rarely happens really, because once the relationship has broken down, really, the WRC are very slow to send the employee back. So the most common way that people are compensated is financially. So you're entitled to be awarded up to a maximum of 2 years financial loss. So for example, if you were to bring a case and you were successful and then you got another job straight away, you may not have any financial loss. So it's important to remember that it's only the financial loss that is calculated. Sorry, somebody has said, and the question and answer is the 8% calculation for annual leave also applicable for full-time work? Your slide mentioned it for part-time work, but is it not also for full-time? It is, yes, it is. So it's just easier sometimes for part-time work when people are working, more, less kind of regular hours, it's easier to use the 8%. So that's why we use it in that example. I hope that answers your question. No, sorry, the next slide. Yeah, so all employers then should have a clear disciplinary and grievance procedure. So a disciplinary procedure applies to all employees, and it's used by employers to sanction employees. So you can't be dismissed, for example, without a fair disciplinary procedure. A grievance procedure then is for the employees to use. So if you have a problem at work, if you're being bullied at work, or if your conditions are not what they should be, you can raise a grievance using the grievance procedure to your employer. So again, it's very important to do that before you make a complaint to the WRC. So moving on then to the Employment Equality Acts, and I think these will be, hopefully you won't need to rely on these acts, but they are particularly important because they do provide really good protections to people in their employment. So they protect people from being discriminated against in their workplace, in their employment, on these 9 grounds. So gender, civil status, so that means whether you're married or unmarried. Your family status, that is whether you have, if you have children, or you are a carer, or you're pregnant. Your age, your sexual orientation, if you have a disability, your race, your religion, and your membership of the traveller community. And sometimes, there might be discrimination. It might intersect a number of those grounds. So for example, gender and family status would often be intersect in that somebody is discriminated against because they've told their employer they're pregnant, for example, but also, that wouldn't be happening if their gender wasn't female. So there can be more than one ground. So the interesting thing about these acts is that if you're discriminated against by your employer, you can make a complaint and you don't need to have 1 year's continuous service. And it's important to remember this at this stage as well, because this also covers people who are applying for jobs or going for interviews. So if you feel you've been discriminated against at the interview process or at the application process, you can also avail of the protections of the Employment Equality Acts and potentially bring a claim to the WRC. So if you can show that you're a member of a protected group, for example, that you're a woman and that you were dismissed because of that, the employer has to prove to the WRC that their behaviour was not discriminatory, that they didn't discriminate. So an example of that would be a claimant who could bring a case if they were dismissed on an afternoon having discussed their religion informally with management at lunchtime. So if that happened, the burden would then shift onto their employer to establish that there was some other reason that they were fired or dismissed, and not the revelation of the employee's religious beliefs. So moving on to harassment and sexual harassment, again, hopefully not something that any of us will have to rely on, but a very important protection to be aware of. So any unwanted conduct is prohibited. So that's known as harassment. And the acts also protect workers from sexual harassment. So it's defined as any form of unwanted verbal, non-verbal, or physical conduct of a sexual nature. So it can consist of acts, requests, spoken words or gestures, or the production, display, or circulation of written words, pictures, or other material. And an example of that is a woman who came in and she was on a WhatsApp group with her colleagues, and her colleagues were largely male, and they were sending very misogynistic and offensive memes and jokes on the WhatsApp group, and that was discriminatory. So an employer can defend against a claim of harassment or sexual harassment if they can show that they have taken reasonable steps to prevent it. So for example, by providing training to staff. So victimization then, this is where an employee makes a complaint to their employee that they feel they've been discriminated against, And on the basis of that complaint, then that they are dismissed or they're punished in some way. So an example of that would be a case that I had where there was a woman working in a fast food restaurant, and she was shouted at by her manager, and she was called a racial name based on her ethnicity. She made a complaint to senior management, and she was then fired the next day. So she was able to bring a claim for discrimination, and she was successful in that claim. And she also brought a claim for victimization to say that she was victimized because she had made the complaint of discrimination. So that can happen after a worker has left their employment. So for example, if a poor reference is given to potential employers and indicates that you previously made an employment equality complaint. So one example again of victimization is where somebody makes a complaint of harassment to their manager, and then as a punishment is switched to the company's unpopular night shift. So there's just two questions there in the Q&A that I'll deal with. You know what, I might deal with the Q&A at the end, if that's okay, just so we won't interrupt the flow too much. I hope that suits everybody all right. But I will deal with all of the questions, and I'll make sure to leave time for that. So the Employment Equality Act then also prevents discrimination on the basis of disability. So reasonable accommodation must be made. So employers must take reasonable steps to accommodate employees with or employment candidates with disabilities. So they have to take they can modify the structure of the job or the physical workplace or the tasks that are given to the job. They're not obliged to provide special treatment or facilities if the cost of doing so is excessive or disproportionate. So an example of this would be an employee who's been working as a secretary for 15 years. She's involved in a car crash which has led to a back injury. She would be able to return to her job, but only if she was protected with a proper chair and a desk. And the desk and chair would be the appropriate measures, which if put in place would allow the employee to return to work. So that would be the reasonable accommodation. So, sorry, the slides are stuck. 1 second now, bear with me. Yes, so these are the remedies then for an employment equality matter. So in order for equal treatment, in order for compensation of up to 2 years' pay or up to 40,000, whichever is greater. So it's important to remember here that under the Employment Equality Acts, do you remember when I said if you take a claim under the Unfair Dismissals Acts, it's only your financial loss that you can be compensated, you can be awarded. But under these acts, you're compensated for the fact of discrimination itself. So it's not calculated based on your financial loss. So it's potentially higher awards. So there's also a separate award for victimization, and in order for an order that the employer take a specified action, and that might be changing their policies and procedures or providing training to staff. Now, I'm conscious of our time, so we'll run through the next part quite quickly, if that's okay. You will have the recording back, and the slides will be available. And again, any questions that you have, you can always come to us at the clinic, and I'll deal with those in the Q&A before I finish up. So redundancy then, hopefully it's not a situation that you will find yourself in, but just very briefly, redundancy is where you lose your job because the job is no longer there. It might be because of the financial position of the organization, lack of work. So your employer has to give you notice of redundancy and a statutory redundancy payment if you're eligible. And they have to be fair in relation to who they select for redundancy. So sometimes you'll find, that somebody might feel they were unfairly selected for redundancy because they just don't get on with a manager, or because, for example, they're a carer and they have to work less hours. So that's important to remember. So your statutory redundancy payment, then you're entitled to 2 weeks pay for each year worked, plus a bonus week's pay. And that's capped at a maximum of 600 per week. So for example, somebody who's working in a job for 5 years would get 2 weeks for each of those 5 years. So 10 weeks plus 1 week, which is 11 weeks pay, and that's capped at 600. You have to be 16 or over. You have to have worked 2 years to qualify for the redundancy payment. And any extra weeks then can be agreed with your employer as part of your contract. So it has to be a genuine redundancy situation, and there must be objective criteria for selection for redundancy. So any complaints then are taken to the WRC. I've put the link there to the complaint forum. It's done online. Very importantly, and I really would like you to take this information away, is that there is a 6 month time limit for making a complaint to the WRC, and that's quite short, really, particularly when people might be still in the job and trying to resolve it internally. But it's very important to remember that even if you start your grievance procedure internally within your employment, it still doesn't stop the clock on this 6 months. So it's really important to get your complaint in on time. It can be extended for a further 6 months, but it's very difficult to get that extension. So the clock starts ticking on that 6 months from the date of dismissal or discrimination or failure to pay or whatever the complaint might be. So these are the types of issues we see at CLM clinics. So employment equality, employees being asked to do unpaid or alternative work, changes to terms and conditions, redundancy issues, health and safety, protected disclosures. So that's making a disclosure about some bad practice in your workplace, or returning to work after COVID, which has been a big one. So if you do want to book a telephone appointment with CLM for legal advice, no matter where you are in Ireland, please do so, and encourage it, spread the word on the clinic, as we're delighted to provide any help that we can. It's a free service, so do use it, and the phone number is 01-8477-804. So now, before I go on to this recent decision, just to illustrate how it all works, I might have a look at the Q&A that are here. So the first person, so daughter working in what was a part-time job. She, however, works full-time, sometimes up to 9 days in a row with no day off, no time off for sick leave, and daily abuse from the public, as highlighted in a Kerry newspaper last week. She's suffering panic attacks now. So that sounds like, you know, there's a number of issues there that you know, she should really certainly raise a grievance. Number one, internally, I mean, there's issues there about you know, whether there's a breach of contract in what she's working. There seems to be issues around breaks, around annual leave, time off for sick leave. She's entitled to time off for sick leave. She might not be entitled to pay for sick leave, but she'd be entitled to get illness benefit from the state, and daily abuse from the public. Now that is actually coming up in the case study that I'm going to, as it happens, in the case study that I'm going to go through today. And this is a huge problem, because you know, people just who are being harassed by members of the public, it, you know, it doesn't happen a huge amount, but obviously your daughter is really having a terrible time with it. But there is an obligation there that the employer must provide a safe environment of work for the employer. And I hope that the decision we'll look at now will kind of give you some guidance on that. And your daughter should get in touch with the legal advice clinic, and we can take her through the steps that she needs to take on that. And the number one thing is obviously to mind her health, which is paramount, you know, obviously. So the next question then, as an employee, how do I know that the templates used for grievance procedures, employee handbook, etc., adopted and used by my employer are legal and legitimate? So the best, I suppose, place to look for that, to the person who asked that question, is that there's a lot of information on the WRC website on that. There's a code of practice for disciplinary and grievance procedures. And that is available on the WRC website. So that provides guidance to employees and employers on what needs to be included in employee handbooks and in grievance procedures. In relation to your employee handbook, you know, like what I'd say there is there are some samples available, but if there are any particular elements of it that you are concerned about, you should come to the clinic and have a chat about it, because, you know, your employee handbook is often a part of your contract, so it's important that that you know that what you're signing up for, really. Yeah, so I hope that answers your question. So those two routes to make sure, so the WRC website, and also if with any particular concerns, do come to the clinic. So I hope that answers it for you there. So what I might do is move on. Yeah, so I think that's all of the Q&A. Yeah, that's great. Okay, so let's move on then, and hopefully this will shed more light on that last situation that person brought up regarding her daughter and what sounds like terrible conditions of employment. So in this, and I wanted to show you what an actual decision might look like in the WRC, applying what we have learned today. And this is a really recent case, actually. So the complainant here, the complainant, Claire was her name. She was an employee of Paddy Brown's pub in Waterford. So she said that she had been discriminated against in her employment, that she'd been harassed and sexually harassed, and that she had then been dismissed for discriminatory reasons. So basically what happened was there was a couple in the pub, and she was very concerned at their behaviour. They were, you know, they were making comments towards her which were sexual and profane. They were seated in the pub, and they continued with this behaviour over the course of an evening. And the complainant in this case, she argued that her employer did nothing to protect her from this behaviour, and that she was dismissed because she brought it to their attention. So she said that she had experienced hostility and insulting commentary from the two customers. So she went to the WRC, and this is what she told the WRC. So she went to her manager on the night, and the two customers were barred from the establishment. But what happened then was that the customers came back and complained, and the employer, the main employer, reversed the decision and said that they're not barred, they are allowed to come back into the establishment. So the complainant had a few days off work, and when she came back to work, she was told that she was no longer required at the business, and she was then subsequently dismissed by text message. So she brought her case, and she said, you know, under those grounds that she'd been discriminated against, harassed, sexually harassed, and dismissed for discriminatory reasons. So the WRC decided that they believed her evidence on the balance of probabilities, that she was the subject of an unwelcome remark from one of the couple, and follow-up profanities from the other person in the course of her work on the day in question. So the WRC found that she satisfied the burden of proof, and that she established what's called an evidential nexus, or a link between this unfair treatment and her gender. So she was able to show that this behaviour was directly linked to her gender, that she was treated that way because of her gender. So on that basis then, the employer then had to show that she had not been discriminated against. And the WRC was highly critical that the incident in question was not recorded, and there was an absence of adequate employment records. the WRC found that the complainant was discriminated against by her employer during the harassment and also in the dismissal. So she wasn't supported at the time, and she was then discriminated against when she was dismissed after the incident. There was a failure to protect her in her workplace. So the pub was ordered to pay her €25,000 in compensation for the effects of the discrimination, and a further €5,000 for her discriminatory dismissal. So she got €30,000 in total. So moving on then, just to finish up, so just to take you through some of the, and sorry, Lisa has put in the chat there the link to the Workplace Relations Commission website. Thanks for that, Lisa, that's great. So the resources that we have to offer you are free legal advice clinics, as I've said. We deal in all areas of law. We specialize in certain areas, but advice is given in all areas. And I'll go into that further. We do have a guide online, and the link is there to taking an employment equality case to the WRC, how you do that and what your entitlements are. We also have, it's not directly related to employment, but I suppose it is in a way. We have a database of social welfare appeals decisions that we compile ourselves and publish on our website. So if a social welfare payment is refused, appeals of those decisions, and that's a really useful resource in terms of social welfare. And we also provide training like today, so talks and training sessions for organizations, and you'll get further information on our website there at communitylawandmediation.ie. So there's our number again. So we provide advice and advocacy services in areas like employment, housing, social welfare and family law, not just that. And I just wanted to say today, unfortunately, I can't speak Ukrainian myself, and apologies for that, but don't let language be a barrier to you seeking help. You know, we do conduct our consultations are through English, but you're very welcome to have an interpreter with you on the call. So if you have a friend or, you know, a colleague or whatever it might be that you'd like to sit in on the call with you to help interpret, that's absolutely fine. And we can make sure that you have enough time in your consultation. We can give you extra time to make sure that you can get your point across, outline your issue, and get your advice explained to you clearly. So you can contact us on that. So just two more links then from the WRC website again. So there are links to employment law explained in Ukrainian language and in Russian as well. So unless anybody, that's it really, unless anybody has any further questions. I can't see any there in the Q&A, but if anybody wants to jump in, please do feel free. And finally, I suppose if there are no further questions, I'd like to thank you very much, and I'd like to again welcome you, and do stay in touch with us. You can follow us on Twitter and on Facebook, and you'll get further information on our website, and our phone number is there as well, to get in touch with us. So I will leave it there if that's okay, Lisa, unless there's any further questions.
No, that is perfect. And if you want to stop sharing there, we can just
Sure.
come back in. Thank you so much, Jane. And I think what's brilliant about that is that there's a huge amount of information. And as I said, it will be recorded, so we will be sending it out to you all after this webinar. And just to say thank you to everybody who came along this morning. We hope it was really useful. And yeah, thank you. We'll sign off here. Thank you.